How will the EU AI Act define AI systems legally? Have you ever wondered how artificial intelligence is classified under the law? The European Union Artificial Intelligence Act provides a clear legal definition of artificial intelligence systems. According to the Act, an artificial intelligence system is a machine-based system designed to operate with varying levels of autonomy. This means that these systems can adapt and learn after they are deployed. They take input data and generate outputs, which can include predictions, content, recommendations, or decisions. These outputs can have an impact on both physical and virtual environments. The definition of artificial intelligence systems in the Act includes 7 core components that describe their characteristics. However, it is important to note that an artificial intelligence system does not need to meet all these characteristics at every stage of its life cycle. Just having one of these elements at any point in development or use is enough for it to be classified under the Act. The European Union Artificial Intelligence Act takes a risk-based approach to regulation. It categorizes artificial intelligence systems into 3 levels of risk. First, there are systems classified as posing unacceptable risk. These systems threaten fundamental rights or safety and are banned outright. An example of this would be government social scoring systems. Next, we have high-risk artificial intelligence systems. These systems significantly impact health, safety, or fundamental rights. Examples include tools that scan resumes for job applicants or artificial intelligence used in critical infrastructure. High-risk systems must meet mandatory requirements for trustworthy artificial intelligence, including assessments of conformity before they can be placed on the market. Finally, there are limited or minimal risk systems. These systems do not fall into the previous categories and are subject to lighter or no specific regulations. The Act also imposes clear obligations on providers of artificial intelligence systems. They must ensure safety and respect for fundamental rights throughout the life cycle of the system. Additionally, the Act prohibits systems that manipulate human behavior in ways that could cause physical or psychological harm, especially when targeting vulnerable individuals. From a legal and technology law perspective, the definition provided by the European Union Artificial Intelligence Act aligns with international standards, such as those set by the Organization for Economic Cooperation and Development. However, there are still some technical and legal ambiguities that need careful interpretation by developers, providers, and regulators. They must determine which systems fall under the Act and how compliance obligations apply. For companies developing artificial intelligence in or for the European Union, it is essential to assess their systems against the Act's definition and risk categories. They must implement required safeguards and undergo conformity assessments for high-risk artificial intelligence before deployment. This legal framework aims to balance innovation with the protection of fundamental rights, health, and safety in the artificial intelligence ecosystem.